Sanibonani babukeli emakhaya. I'm Luanda Tsiketi and you are watching uMkhonto Wesizwe Updates channel. Two of uMkhonto Wesizwe Party leaders, Bonginkosi Khanyile and Visvin Reddy, have been slapped with suspended sentences by the electoral court. This is after they were accused of making comments inciting violence ahead of the national general elections held on the 29th of May 2024. Legal analyst Mr. Modidima Manya spoke to Newsroom Africa to give his interpretation of the court's decisions regarding the two uMkhonto Wesizwe Party leaders. Listen to this.
Yes, good day, Hugo and your viewer. Look, the courts, whenever they make a determination and determine how to deal with a person, consider a variety of factors. And in the main, courts adopt a corrective approach. And I suppose that in this particular instance, the 150,000 fine suspended for 5 years was meant by the Electoral Court to be a corrective approach, as opposed to being punitive. Otherwise, the court could have removed the suspended part and in fact could have even probably determined that they've been imprisoned. But remember the position in law that each case has to be judged on its own facts and surrounding circumstances. So we cannot say because there was violence in July as a result of some inflammatory statements made not by the same people who appeared before the Electoral Court, then the court must punish this once. Everybody must appear in court in their own right and be judged accordingly, not necessarily because out there's an outcry. The courts do take into account, of course, and you would have seen in many instances where people apply for bail, courts do consider the views of the community to the extent that they are relevant to what they are determining. So I wouldn't necessarily want to have a one-size-fits-it-all. It may as well, and I think this is sanctioned by the Electoral Court, does not by any means, in my view, suggest that it is trivializing the seriousness of their statement. I mean, an amount of 150,000 is a lot of money. And by the way, what this means is that if they repeat what they have done, then they will have to pay the amount of 150,000 and probably face more sanctions because they will also be in contempt of court. So it's not a small matter. Well, you know, a precedent in law is a decision of a higher court which is binding on other courts to create legal certainty. So precedence is not necessarily that if I'm fined R5, you must be fined R7 or R5 because I was fined 5. As I say, every matter has to be judged on its own facts and surrounding circumstances. That's a fundamental principle of our law. Having said that, I think there's obviously a need also for the courts to be more firmer, because conduct of this nature, as the court correctly found, strikes at the heart of our constitutional democracy. You know, elections is one of the key elements of our constitutional democracy. Now, if a body like the Independent Electoral Commission is being undermined and the integrity of the electoral process is being challenged by through spurious allegations which cannot be supported, then we run the risk of the general public losing confidence in our electoral process and in our constitutional democracy. We are now heading for a disaster. So it is a serious matter, but I think the courts have got the discretion to determine at any given stage what would be an appropriate sanction. Look, you know, we shouldn't, Hugo, ask the courts to, you know, determine how political discourse must take place. The Constitution is very clear about how people must conduct themselves. I think that we are in a sad situation because we have moved to a stage where in this country, people form political parties and make all sort of irresponsible statements, but you've got so many people, I don't know whether it's gullibility or something else, but people follow them. I mean, I cannot understand when somebody makes the type of statements that these people make without providing any support or supporting evidence. And there are people who seem to think what they are saying makes sense. I mean, it's not good for any one of us, whether we support their political parties or not. It's not good enough. But I think our standards are very low in this country, both in terms of ethics and in terms of compliance with the law.
Now, the IEC
Well, look, I think the law is very clear about who qualifies to be a candidate, who doesn't qualify. The courts will always tell you that their function is not to make the law, but to interpret the law. I think the IEC may have had good intentions to have people who disregard and disrespect the electoral process being disqualified. But unfortunately, in terms of the Electoral Act, is not one of the disqualifications. You will recall that when there was a big debate about whether Mr. Zuma can qualify, there was a whole sort of interpretation of the disqualification criteria for people to be members of parliament. So it's not really one of those requirements. If they were found guilty of an offense and sentenced to a sanction without the option of a fine of more than 12 months, then they will be disqualified. But by virtue of just misconducting themselves in this manner, I don't think it warrants disqualification.
Now, Visvin.
Well, I think this is what it probably gives credence to what you probably also raised about whether this is not just a slap on the wrist. When somebody has been found by a court to have misconducted himself and he comes around and he had the opportunity to ventilate, he's taken out of context in court. The court did not find that it was taken in context. In fact, if you watch the video where he speaks, there's no ambiguity about what he's suggesting. So he's actually coming up with a lame excuse. It simply may suggest that he's unrepentant. And this is what makes people lose confidence, including in the courts, because then people are saying, well, he should have given a more harsher sentence because he has now been given a 150,000 fine, suspended. Now he's basically repeating by saying that it has been taken out of context. He's actually repeating what he said, and he's standing by what he's saying. Non-governmental organizations participating in court processes, The court is, of course, enjoined to consider what is before it. It's very difficult to say what is the public saying unless somebody comes before court and say, this is the general view of the public, or this is some researched view of the public, because it's also dangerous just to simply for the judge to think the public is angry because he cannot be party to the proceedings. I think this calls for society itself to make its voice be heard, because nothing precludes members of society from participating in legal proceedings, especially on matters of public and national interest such as this one. So the difficulty that we have in the country is often society which is offended never makes its voice to be heard by the courts, putting the courts in a difficult position. So it's a bit of a difficult one for the courts to simply say the public. The courts will say, is it in the interest of justice to deal with a matter in a particular way, and of course within the constraints of what the Constitution and the law allows. Fine is 450,000. It's suspended, and one of the conditions is that they don't repeat what they have done. Now, if they repeat what they've done, firstly, they are in contempt of court, but secondly, the fine becomes active. So the condition of suspension is that you don't misbehave again.
As a IEC this time around. It is actually the first time that I've seen the IEC target a single party like this. It actually raises some eyebrows. But yeah, we're glad that this case is over and done with. That is all from us today. Please take a little time to subscribe to this channel for free. Like this video and share the video link with your family and friends. This is Ulianda TKD signing out.